Members can do the needful with any electronic devices. We've no apologies at this stage, Mr. McGlone.
Mr. McGlone, his wife had an accident, so he's at the hospital.
Okay. Draft minutes of the meeting that was held on the 21st and 22nd of October. Members are content with their accuracy, then I'll sign them accordingly. Some matters arising. Item 1, correspondence from the leader of Fianna Fáil, Nicole Martin, TD, had requested a meeting with myself as chairman in relation to the Maria Cahill case. He wrote on the 21st of October, and I subsequently met with Senator Jim Walsh and some other people on Mr. Martin's behalf. Obviously the letters there for members' information. I indicated at the meeting that the committee was considering its options in respect of this issue. He obviously in his letter indicates a willingness to have some kind of north-south cooperation, and I obviously intimated that the committee hadn't taken any decisions in respect of this issue, but that was something that the committee would give consideration to. The forward work programme, members is in your meeting folder. It sets out the updated position in respect of the oral evidence sessions on the Justice Bill and the proposed amendments, and they're on pages 3 to 7 of the table pack. Just to inform members, the Chief Executive of RQIA has written to the committee advising that he's unavailable to provide oral evidence to the committee on Jim Wells's amendment at the meeting on the 3rd of December. As the committee has requested, Mr Houston has advised that the RQI senior management team consider the written submission to be self-explanatory and therefore do not wish to reschedule the oral briefing. A copy of the RQIA's letter is in the tabled pack at page 8. Obviously, if members have had it, and I wouldn't anticipate these have had an opportunity yet to read all the submissions, but RQIA did give a very detailed submission, and they were opposed to what the amendment contained and provided quite a lot of detail into why. I felt that it was important to hear from them, given the detailed written submission that they provided, to allow the committee to scrutinise that and interrogate it. But they obviously don't want to come to the committee, and I don't think that's an acceptable position, particularly given that they're a public body. So if members are agreeable, we will write to RQIA asking that they would reconsider that position, and that we would copy in the Health Minister and the Permanent Secretary of the Department of Health into that correspondence. If members are agreeable, we'll do that. Yeah. Also, to inform members, a response has been received from the Health Minister on the Justice Bill, which focuses on the Attorney General's proposed amendment, and a copy of that letter is at pages 5 to 7 of the tabled pack. The committee previously agreed that if a written submission was received by the Department of Health, that it would be invited to give some oral evidence. Arrangements will now be made for the Health Department to give that evidence in respect of the Attorney General amendment in January 2015. That's obviously in relation to powers that he's seeking to do with inquests where there are deaths in hospitals. The draft budget consultation, following the publication of it, a copy of the draft budget is included in the table pack for members' information. A briefing with officials on the budget will be scheduled before the Christmas recess. Obviously, members, there's also correspondence related to this draft budget issue around Desert Crate Training College, and that was circulated to members. The department had intended to give oral evidence on this issue at a meeting on the 10th of December. If you look at the draft budget, there is actually provision has been put in of £53.3 million for the college, but yet there's a letter from the Minister indicating the steering group's view that it shouldn't be proceeding, but there's a 2-week review. So it had been planned to schedule a briefing on the 10th of December. Obviously, if members are keen, we can seek to bring that forward to try and find out exactly what is going on in respect of this issue. So I'm open for members on that. Mr. McCartney?
Yeah, I think we should try and do it as quickly as possible, because it would be an aid to the public consultation on the draft budget anyway, to have a final decision, rather than, it's nearly a no maybe at the minute.
Yeah. Okay, so
I just want to agree with that. I don't fully understand the rationale for the group's decision not to proceed. I would be very interested to know what the Minister for Justice, what his view is in relation to this matter as well, particularly when there is a 53 million provision in the current budget, or draft budget. It seems very curious to me that this decision is made in the light of that financial provision.
Mr. Pitts?
Yeah, I think that the process has been a shambles from the outset. That set themselves up as going to create this college which wouldn't only just meet the needs of Northern Ireland but be a training college for police, prison officers, fire emergency staff from around the world. And they were actually spending, I think it was close to £50 million underneath the ground. Roadworks, drainage works, diverting rivers, land works. Absolutely phenomenal, just what the plans were. They brought in a team of Americans to plan it. And of course, Americans operate on a scale which is not quite used to Northern Ireland's population of 1.7, 1.8 million. And consequently, we have ended up with just a whole process of shambles. Now, this is public money. In £12 million, over £12 million spent on it, with no outcomes. And I don't think that the committee can just sit back and allow it to happen without carrying out some course of work as to what went wrong. Was it the right process that was followed in the first instance? I listened to Deputy Chief Constable many years ago, and I just think what they were aiming for was absolute pie in the sky, and it's actually quite outrageous that they have done what they have done and spent the money that they have spent for something which I think, if you closely inspected business cases, would be very difficult to justify.
Well, obviously, the committee has extensively scrutinised this, and it's on the record and will show the level of interrogation and concern that we had over the past number of years. And I'm more than content that we would schedule a meeting as early as possible on it. If members are agreeable, we will try to do it on a sitting day, because we have 3 orals planned for next week, 3 orals the following week, and having had a look at the order paper, there's not that much justice-related items coming through the Assembly on the Monday and Tuesdays. So if members are agreeable, we'll try schedule something on one of those days within the next 2 weeks, as early as possible. Paul?
Yeah, Chair, I would agree with that, and I would agree with the assignment of having it in a sitting day. Agree with everything that has been stated there with regards to the public money and the money that has been lost now with regards to the shambles, but also remember that there have been thousands upon thousands of pounds spent in the private sector with regards to tendering processes, and successful tendering in the end. And that is all lost to those companies. It is an absolute sham. This has been allowed to creep on the way it has, and then to close the way it has, and to end the way it has. So certainly I think it's something we need to scrutinise very, very carefully.
Okay, could I just come back on that point? I know Mr. McGlone was here, he represents the Mid-Ulster area. He would be emphasising the loss to the local economy. Now, I know that this wasn't designed, as it were, to boost the local economy, but it certainly would have, and local economy there certainly needs a boost. So that's a very important issue. I think people feel let down. I think local builders, traders, business people in the area feel very let down in particular. But also, and I understand the points that Mr. Poots has made in relation to the probably the scope of the building and so forth. But you know, this was envisaged in the Patten report in order to create a first-class world leader in relation to police training. Although that, and I think that was a noble and ambitious objective, but I think it's an important objective, and one that I would have thought the Department of Justice should have been faithful to. And I am extremely disappointed that this has not turned out to be a positive endorsement of that objective.
Chair, in relation to the fact that this is a cross-departmental procurement exercise, in fact, the Department of Health Centre for Procurement Excellence were the people who led and were responsible for the procurement of all of this, the consultants, the Americans and all of that. To what extent will this, I mean, can this committee effectively establish a cross-committee opportunity to question this matter? Or are we already the lead committee in terms of can we invite the people from the Department of Health to come along and answer some of the questions, which are legitimate questions around this table?
Well, the individual from COPE had always previously came to it. Now, not for me to remind members from the last Hansard, we asked about this, and I asked the representative from Health. They were there to oversee what the police were doing. They were the lead. They were responsible.
Yes.
It wasn't actually COPE. I know there's someone else beside.
Presumably, if you've got the name excellence in your, the word excellence in your title, you do have some form of advisory and cautionary role as well.
I think they got involved when the ship had already sailed.
About a year and a half ago.
Very well be right.
Whenever we do it, it should be after the decision. You know, because I think the other day was this uncertainty around it. You know, was it shouldn't proceed, but there's a 2-week review, and you're left. And I think what we need, whenever the decision's made, because you know, the wider issues, and even the thing this week about the procurement over the railway line from Coleraine to Derry, you know, the understating of it. I think whatever the outcome of this is, it may be a time for all the committees and all the departments to look at central procurement.
Yeah.
What the mistakes are being made that cost the public purse in a time when no money is particularly scarce.
Well, I think that the first stage is to try and bottom out what's going on in terms of the current decision-making process and where that rests. The issue about interrogating what went wrong and how this was managed, in the first instance, I would be recommending that we would be asking the Northern Ireland Auditor to do that and the Public Accounts Committee to do that. They would be the appropriate bodies to be going through that in a more forensic way than this committee is actually mandated to do. So that's where that type of level of interrogation, first of all, should be. And then once they do their work, of course, this committee can pick it up. But in the first instance, post-decision, it would be for the auditor to look at.
No, I agree, but the auditor's process could be 18 months or 2 years.
Yeah.
In the meantime, there'll be another 4 or 5 procurement contracts in the pipeline, all in the same system. So whatever we do, and I don't want to predetermine the outcome of this particular decision, I think it might be an appropriate time to look at how, you know, as a whole, the Assembly procures, because there just seems to be too many mistakes, and it always seems to go back to the procurement process as much as anything else.
Okay, so Happy will schedule a meeting within the next fortnight on a sitting day to meet with the steering group and the Minister to find out where this currently sits in terms of the decision-making process. Okay. Okay, I'm going to change the agenda slightly and deal with the inquiry issue. I know, Tom, you have to leave it.
Chair, yeah, about 3:45 that talks,
Yeah.
but
So,
I was going to actually suggest maybe, because we've discussed it in closed session, might be useful to bring it forward, that
Yeah.
item.
Well,
But it's your prerogative.
Well, the clerk had advised me you'd been in contact about trying to move it on so that you wouldn't miss it, so we'll deal with that particular issue at this juncture of the meeting. Okay, obviously, members will be familiar with it. We've discussed some of the legal advice in closed session, and obviously just to remind members that was in closed session, so bear that in mind in terms of any comments that will be made now in public session. We did, at our meeting on the 21st of October, letters were issued to the Police Ombudsman and the Director of the Public Prosecutions Service requesting further information regarding the timescales for completion and publication of the investigations and reports that were discussed during that oral evidence sessions. Members will be aware that relates to Jerry Adams. The Police Ombudsman has responded indicating the investigation into the complaint regarding Maria Cahill case is at an early stage, and it would be inappropriate to provide a timescale in advance of crystallising the true nature of the complaint. The Ombudsman also confirms that a closure letter in respect of the Anya Adams case will be issued by the end of this week's outlining the reasons for the delay. A copy of the Police Ombudsman letters at page 79 of the tabled pack. The Minister of Justice agreed to review the Spotlight programme with his officials to identify any implications for the Department of Justice. A letter has now been received from the Department, and that is on pages 82 to 84 of your table pack. The Minister has indicated that he has written to the Director of the PPS and the Police Ombudsman to highlight the concerns raised during the oral evidence session regarding the apparent delay in publishing the findings of the Attorney-General's review of the decision by the PPS not to prosecute Mr Jerry Adams following a police investigation and the Police Ombudsman report into the related police investigation. The Minister has also written to the Secretary of State asking for any comments she may have on the allegations in the Spotlight programme of political interference, given they appear to predate the devolution of justice, and he will provide the committee with a copy of any reply that he receives. The Minister has also indicated that he remains of the view that in relation to the Spotlight programme and the Maria Cahill case, the investigation of a complaint by the Police Ombudsman and the review initiated by the Director of the Public Prosecution Services are the proper channels for such complaints, and he remains unconvinced that a separate review by him is necessary at this point. He has also written to the Director of the PPS requesting an early indication should Sir Keir Starmer have concerns about the support for victims across the justice system, or if he's concerned about any other cross-cutting issues before his review concludes. The Minister has advised that if either report indicates a serious or systematic problem within the justice system, he is prepared to request the Criminal Justice Inspection undertakes a system-wide review of those issues. Obviously, the letter also indicates that this committee may establish its own inquiry, and that he would then provide support to that if the committee decided to take that forward. So it's with the committee now. Obviously, we've discussed it, and the Assembly debated it yesterday, and the motion was passed yesterday. And this committee has raised the item now in terms of what we should be doing as a committee by way of holding an inquiry into it. Previously, we got legal advice in respect of what we could do, and that was around the issues relating to the Maria Cahill case and the Anya Adams issue in respect of Jerry Adams. And we've received that advice in closed session, and it's obviously now for members to decide the next steps forward. So I'm happy to open it up to members now for comments. Mr Elliott.
Chair, thank you. Obviously, we can't go into the legal advice that we received there, but I am disappointed that the Minister is not taking a more active role in participation in it. From the Department's point of view, I believe that there is a remit and oversight, and I suppose we were holding off, or at least I was, the last day that the Minister was here. I did question about how long it would take for him to come back with information. He has come back. which basically says he's not going to carry out any further review. I believe there is an onus on this committee to take a review forward, and I know that it needs to be in the wider aspects of justice policy issues, but that does not prohibit us bringing members of the department here to spell out some of the issues where we may have considered, or others may have considered, there were shortfalls and downfalls in the system, and obviously we can call witnesses from the wider public as well.
Okay. Mr. McGuinness?
Chair, I agree with what Mr. Elliott has just said. I did anticipate that the Minister would say what he did say, and I think he's been advised properly in the respect of his functions, but we have a specific function here as a committee, and I think that we ought to pursue an inquiry. We've received legal advice, and I'm not going to disclose that legal advice, but there's nothing within the legal advice that I could see that presents any obstacle to an inquiry taking place. What we need to do, really, I think, if we agree in having an inquiry, are the terms of reference, and that's another day's work. But I think that we do have a duty to investigate, and I think we ought to start that process as soon as possible.
Yeah, I mean, obviously we have got legal advice which we can't discuss, but certainly we would want to take it away in assisting the process of drafting the terms of reference, but we would say that we believe that the scope should be broadened, and we will be coming back to say that.
Any other members?
Chair, my only concern is one of prematurity and allowing the Minister to do what it is he's been advised is the correct course of action for him as a Minister, and therefore that might be to the advantage of the committee to have all of that information in place, whereas if we proceed too quickly, we will not have the Ombudsman and the PPS reports in a timely fashion, and also the Minister's clearly indicated his willingness to refer the matter on to Criminal Justice Inspection. Now, Mr. McGuinness has said those are all appropriate steps, and I think we should look at the potential for draft terms of reference, and Mr. McCartney suggested that he would obviously have a view on how broad and how wide that is. We do have to consider the legal advice that we've been given. But I think my only concern with this would be one of prematurity, and that is not in opposition to us inquiring. It is just simply to say that to get best advantage from it, we need to ensure that everything is in the right place.
Mr. Poots?
Yeah, we're in the first week of November, and by the time we initiate an inquiry, set up the terms of reference and all of that, we won't be fully engaged until the new year. And I think that as each week passes by, the excuses coming from PPS and indeed the police ombudsman are wearing thinner in terms of not producing the reports that have been sitting on their desks for a very, very long period of time. So their credibility is on the line here, and it's being damaged as they hold back. We remember here, folks, that what we're talking about is justice, and it's justice for people who have been sexually abused as children or young people, underage. And that is at the core of this. And we must take whatever steps we can to ensure that confidence in the justice system is such that victims will come forward and victims will speak out. And we are aware that victims in the past have been reticent and reluctant to come forward and tell their stories, and that isn't good enough. So I think it's incumbent upon someone to do it, and no one else is stepping up to the mark to do it. So I think within the constraints of this committee and its authority, I think that we have to proceed with it, and we have to ensure that we make it as wide-ranging and as broad in scope as possible to ensure that what should be done, and that is people who have been harmed by others, have the confidence in the system to come forward and ensure that those people are duly tried and punished where they are found guilty.
Okay. Well, obviously, the committee first needs to take a decision to agree that we're going to hold an inquiry, and we haven't done that yet. And we've got advice. On the basis of taking a decision that we will hold an inquiry, terms of reference then need to be drawn up to be subsequently agreed by the committee. But to do that, we need to be given clear guidance as to the area of inquiry this is about, to allow terms of reference to be drafted. And obviously, there's only so long we're going to be able to do that in a way that won't frustrate us getting on with doing the job. So we had the Assembly debate yesterday, bearing in mind the vote that took place yesterday and what it related to. The broad theme is around public confidence in the criminal justice system. That is the broad area of concern. And the reason that there is concern about confidence in the criminal justice system is because of the issues that were revealed in the Spotlight programme, subsequently debated yesterday in the Chamber, and that is in respect of those allegations of sexual abuse emanating from within the Republican community and how that was dealt with by senior individuals in the Republican movement. So I'm going to put it to the meeting now that is the general area that we would be looking at, public confidence in the criminal justice system in respect of how sexual abuse has been handled by the criminal justice system emanating from within the Republican community around the Republican movement.
Well, we obviously wouldn't be supporting that, and we're mindful what Mr. Poots has just said. I would agree with him. It should be as broad a scope as possible. It should be about sexual abuse within the community. Because there was other issues raised in the debate last night of our allegations of sexual abuse emanating from our quarters.
I'm only going on, and this was the amendment that the SDLP brought forward, believes that the scale of the abuse perpetrated by members of the Republican movement needs to be determined with accountability.
So, I mean, with respect, the debate doesn't bind the committee in terms of setting its remit or its scope.
No, that's true.
So that's where I mean, we have no issue with an inquiry into full disclosure around sexual abuse. But there are many other people within the community. In recent weeks, we have had it over Kincora and our issues, who will be looking on and saying, is this going to be a narrow or is this going to be broad? I'd agree with Edmund Poots, it should be as broad in scope as possible.
Well, I think the difficulty we have, Chair, and that is that we already have an inquiry which is taking place under Lord Justice Hart. The issues that we are referring to and have been referred to are not within the scope of that inquiry. So I think we need to have, certainly clear blue water between the work of Lord Justice Hart and the work that we do. And we shouldn't be creating an impediment or distraction to that particular course of work and starting to get involved in things that he is actually considering. If we're not satisfied with how he's carried that out, the conclusion of it, then that's something for the committee to look at that point. But certainly those who are outside of the scope of his inquiry, I'm happy to look at.
Mr. Frew?
Yeah, and I take the points with regards to wide-ranging inquiries and that this is an evil that's spread across all spectrums. I have certainly no argument with that, of course it is, but I think what has brought this into stark context, of course, is the Maria Cahill instance and what she has experienced on the subject and what she's been subjected to. And whilst there are other organisations who are being investigated and have been investigated in the past, there's no doubt about it, the Republican movement had the wherewithal and the army and the will and anything else sinister at their disposal to cover up, to interrogate and to torture people who would wish or would have wanted to present themselves to the authorities and who were prevented from doing that. And I think that's something, whilst this is in front of us now, we are duty bound to do all we can to shed a light on that murky underworld that people have been subjected to. So I'm in full support of the chairman on this.
Okay, members, is there any other commentary around this? So, to be clear, in terms of what I'm suggesting, it is an inquiry to be held into issues of public confidence in how the criminal justice system has handled issues around sexual abuse and from within the Republican community involving the Republican movement. That's the broad area that I'm suggesting that we would then get terms of reference drafted on.
I would have a counter proposal. So,
Yeah.
and the counter proposal would be, I mean, the first set of words you use in inquiry into how public confidence in the justice system was dealt with in relation to allegations of sexual abuse.
Yeah. Well, my proposal is, I'll put both to the floor. My proposal is in line with what the Assembly voted on yesterday, which the SDLP put the amendment to. This related to the abuse perpetrated by members of the Republican movement needing to be determined with accountability. So that's the remit of an inquiry into public confidence around the criminal justice system that I would be putting to this meeting now. The terms of reference would then be drafted in respect of that. So we're clear on the two aspects of it.
Chair, can I just ask both proposers, are they setting a time frame within which they're referencing this abuse? Are you, or Raymond, both, are you setting a time frame? I
mean, I agree. Like, I mean, in terms of what you're saying, in terms of full disclosure, mindful of what Edmund Hoots has said. I mean, if the minister says he can do it within 3 months or whatever, then fine. You want to have full information. This is about full disclosure, so there's no issue. Are you talking about the time scale of?
I'm talking about the time scale, you know, because historically.
Yeah. Well, I mean, I think you have
If we limit for the sake of argument, we limit ourselves to 2 cases, as the chair's been indicating. What about what happened the day before, or a week before, or a month before?
Those are issues that will be secondary to determining how the committee will then advance the inquiry once we've taken that decision. The committee will then need to determine what cases can be looked at in terms of the broader remit of the inquiry, and the committee will need to decide how far back do you go or how narrowly scope do you go. That's something that will come secondary to the decision.
Would the intention of the inquiry also be, Chair, to draw out those people who have not come forward at this stage? In other words, is this about giving an opportunity? Is this another opportunity? I know people in speeches say go to the police and talk to people and all of that, but is this committee also sending out that signal? In other words, that here's another place you can come to?
Well, the starting point in all of this, in terms of where I'm coming from on it, was the programme broadcast by UTV Insight and the programme broadcast by BBC Spotlight.
So there's no reference to the first programme in the Assembly, in terms of the Assembly motion, but yeah, we only extended that.
How the committee will want to consider how broad and how wide it goes will be a matter subsequent for the committee to decide on. Okay, so members are clear on the 2 proposals? Okay, well, I'll put the one that I've put to the floor first, and if that's carried, then obviously yours will fall.
I think it should be a recorded vote for both.
Happy to do that.
Okay.
Those in favour of what I've proposed, raise your arm accordingly. Alden McGuinness, Paul Given, Paul Frew, Edwin Poots, Stuart Dixon, Tom Elliott, Sammy Douglas. Those against? Those abstaining?
No abstaining, no abstaining.
Raymond McCartney, Chris Hazard and Sean Lynch. Those in favour of the proposal put by Raymond McCartney, please indicate. Raymond McCartney, Chris Hazard, Sean Lynch. Those against, please indicate. Alden McGuinness, myself, Paul Frew, Edwin Poots, Stuart Dixon, Tom Elliott, Sammy Douglas. Okay, well, obviously we will seek to draft terms of reference, and the clerk will liaise with the legal services around that as well and bring that back to a future meeting of the committee to be agreed at that point by the committee. Okay, thank you very much. Going back to the original agenda. The draft Victim of Crime Charter, and it's the result of the Department's consultation at our meeting on the 14th of May. The committee considered publication of this draft Victims Charter and agreed that it was content for the consultation to take place and to consider the matter further when the results of the consultation were available. The Charter is one of the recommendations in the committee's inquiry report that members should be familiar with. Officials are here today and you're welcome to join us at the table. The relevant pages for members in your meeting folder are pages 25 to 181 of the meeting folder. Let me welcome Moira Campbell, Deputy Director of Criminal Justice Development Division, Veronica Holland and Maurice Campbell, again from the same division and department. As usual, we'll record this meeting by Hansard, and then a transcript will be published in due course. So, Moira, I'll hand over to you at this stage.
Thank you very much, Chairman. We've now completed, as you say, our consultation on the draft Victim Charter and a summary version of that, and have provided you with a paper which gives an overview of the feedback we've received and the Department's response to this. The feedback received was generally very positive, and we've taken on board most of the suggestions that were made. Many of these were about clarification or additional information rather than the content itself. For example, we were asked to explain more about how restorative practices are used and to make it clear that the entitlements would apply regardless of an individual's nationality. We were also asked to change the title to Victim of Crime Charter, and we'd indicated in the papers that we were minded to receive this or to accept this, though I should highlight that we've since confirmed with our legal advisor that we should use the title given in the primary legislation, which is the Victim Charter. So we may instead add a strapline under the title to make it clear that the Charter is in respect of victims of crime as opposed to changing it. A key theme throughout the consultation was the need to highlight the support available for victims of particular crime types, such as bereaved families, victims of domestic or sexual abuse, hate crime and trafficking. And the revised version of the Charter contains more information on those specialist services. There was a useful point put forward about the operation of victim personal statements, and we've now amended the Charter to allow the person making the statement, which would be either the direct victim or a member of a bereaved family, to set out the impact of the crime on other members of their family as well. There were a couple of drafting suggestions that we didn't take on board since we were keen to reflect as closely as possible the text of the EU directive on the rights, support and protection of victims of crime, given that the Charter is being used as our principal mechanism for transposing the directive. There were also a few points raised that we felt were outside the scope of this Charter, such as points raised around support for defence witnesses, defendants or children of defendants, and also crimes that were committed outside this jurisdiction that wouldn't be investigated or prosecuted here. Now that we're hopefully close to finalising the Charter subject to your views, we've been looking at ways to ensure that we make it as accessible as possible, and we gleaned some very useful ideas on this from the consultees. Firstly, we're intending to have the summary version translated into the 6 other languages most commonly used at police stations and at court, and we've indicated in the Charter that other formats can be made available on request. A new victim of crime leaflet is also being produced, and that will be available in other languages as well. We've shared with you an easy read version and a young person's guide, which were produced during the consultation process. The easy read version was produced by a company called Making It Clear, and the young person's guide was written by a group of young people with the assistance of the NSPCC. And what we think is best about these versions is that neither of them looks as though it was written by a civil servant, and we're very grateful to all of those involved in their creation. We've shared these versions with a number of voluntary sector bodies which may have a particular interest, and if we receive any comments back from them, we'll consider those. We've also asked the agencies to ensure that the Charter is available on their websites, and most importantly, I suppose, to make sure that staff are aware that it exists and to make good use of it. We've also started work on a dedicated Victim Charter webpage and a poster to advertise the Charter in public places. And as part of our next action plan, we're hoping to create an online walkthrough of the criminal justice process and a DVD. So we'd welcome your views today on the revised Charter, and subject to these, we would hope to publish the Charter by the end of December and to launch it formally in January. And as always, we're happy to take questions.
Thank you very much. And obviously, I welcome that we're getting to this point. There's been considerable work both by yourselves and this committee. I think it's been a good example of how committees and department can work together and come up with a document that I suspect will now be wholeheartedly supported by people. I suppose that, when you touched on it at the end there, obviously the document is very good in terms of what it says on paper. And it'll be the reality of how this is implemented across the organisations. And first of all, how are we going to make victims aware of the type of services that they should be expecting and the rights that they have? And hopefully the legislation, when we put that in as a statutory footing, that will help. But they will need to be aware so that they can be being demanding of their rights to have that. But also the organisations, it needs to be very much ingrained as part of their culture, because obviously you'll know from our inquiry it was found, particularly in the PPS, damning criticism from victims as to how they were treated and how they handled that issue. So how is this going to permeate throughout the different agencies to affect the culture that needs to be there to make this strategy work?
I think we'll be trying to do that in a number of ways, and for instance, we've been discussing this with the victims' champions that have been appointed at senior level across all of the agencies, and really underscoring for them the importance of making this a key document in terms of ensuring victims' services are being provided. And we've looked to their commitment to ensure that it is delivered, particularly at a time when there are reduced resources. We want to make sure that this continues to get a high priority, and we are being assured by the champions that they will take that on board. At a working level, through the Victim Witness Steering Group, we've been having a lot of discussion with agency representatives, policy leads, and with the voluntary sector organisations that we work with, Victim Support and NSPCC, just about ways of promulgating this to staff, factoring it into their training plans, and making good use of the various bits of documentation we're providing, like the summary, like the Victim of Crime leaflet, which will be handed out by the police to all victims of crime, and will be available in other fora as well. So I think you're right, having got to this point is good, but the Charter will be as good as the services that are provided and the information that's given to victims. So ensuring this is communicated effectively to victims will be an area that we'll want to focus on for the rest of this action plan and our next action plan under the strategy.
Okay, thank you. Mr. Lynch?
Yeah, thanks, Chair, and thanks, Maura. And as the Chair said, we welcome the finalised or finalised document. There's just one particular something I wanted to clarify. You mentioned about complaints to an independent body. What shape does that take, or who are the independent body?
Largely through the Northern Ireland Assembly Ombudsman. There obviously are a number of other independent ombudsmen, such as the Police Ombudsman, There's also an independent body in relation to PPS, but largely through the Assembly Ombudsman for the vast majority of organisations. For the voluntary sector support bodies such as Victim Support and NSPCC, if the complaints aren't resolved successfully or to a victim's satisfaction in the first instance with those organisations, they would then be able to come to the department as funder of those bodies and raise their concerns with us.
That's fine.
Okay. I'm not going to prolong it because we've been up and down for a number of years. So, Mr. Dixon.
I just wanted to say well done in getting it to this point, Chair, and to welcome particularly the simple guide and the young person's guide, because central to most people will be their court case, the crime that has brought them to this point. And this is another, for many people in the first instance, this will be just another piece of paper to read. And if a simple version gets over to them the nature of what's available, I think that's very important. Thank you.
Okay. Well, thank you very much.
Thank you.
I think it's right to put on the record now that we're getting to the point this will be ultimately launched. My thanks to the officials, yourselves, Moira especially, and to the Minister, because you obviously were ready to go with a draft strategy and we asked you to wait to allow us to do our inquiry. And I appreciated that, and hopefully working together you've appreciated our contribution, and we've come up with a strategy that I think is something that the department and this committee can be rightly proud of, in terms of something that we will look back on and say, yeah, that was worthwhile, we achieved something. So thank you very much, and I appreciate your efforts.
Thank you, Chairman.
Thank you.
Thank you. Okay, members, we're just changing the top table here. Kate's going to join us for the next item. Who's leading on this within the committee? This is pages 183 to 218 of your meeting, and it's to get a briefing from officials. Simon, come on ahead, Simon. In respect of the LCM on Northern Ireland provisions in the Modern Slavery Bill, the proposed LCM will cover three main areas within the Modern Slavery Bill, and obviously they'll be touched upon by Mr. Rogers. The committee has previously considered the proposal to extend the remit of the Anti-Slavery Commissioner to Northern Ireland when considering Clause 16 of Lord Morrow's Human Trafficking Bill, which provides for a Northern Ireland rapporteur to monitor and report on the response to human trafficking in Northern Ireland. So can I welcome Simon Rogers, Deputy Director of the Protection and Organised Crime Unit, and Julie Wilson, Head of the Human Trafficking Team. You're both very welcome, as usual, to the committee, and we'll record this by Hansard and publish it in due course. So, Simon, I think I'm handing over to you at this point.
Thanks very much. As always, grateful for the opportunity to brief members on the content of the Minister's proposed legislative consent memorandum, which seeks to extend certain provisions in the Modern Slavery Bill to Northern Ireland. You'll obviously be aware that good progress has now been made on the Human Trafficking and Exploitation, etc. Bill, and we're now waiting for further consideration stage on that, with the date yet to be set. The measures in the Modern Slavery Bill which we wish to see extended to Northern Ireland under this LCM are intended to complement that bill and to ensure that we're the most comprehensive and effective package of measures and legislation that we possibly can have. And as the Chair's mentioned, there's three elements. You've previously been briefed on two of these, which are the Anti-Slavery Commissioner and the Maritime Powers. And in addition, the paper we've sent you sets out an additional area to tackle trafficking and forced labour by enhancing transparency in commercial supply chains. We had hoped and indeed expected that the Modern Slavery Bill's report stage would have taken place in October, and that would have enabled us actually to be here today talking about an LCM in front of you. Unfortunately, that stage didn't take place until yesterday in the Commons, and the bill has only therefore been settled on these points. So we're finalising our draft legislative consent motion, and we hope to lay it in the Assembly early next week. It will, however, reflect what's in the paper that you received on the 28th of October, and I'll touch on a couple of points in a moment. The Minister, in looking at the proposals in the legislative consent motion, has, of course, engaged with the Home Secretary, but has also made sure that those provisions reflect Northern Ireland circumstances and needs. The written paper sets out the three areas, but there's a few aspects that I probably should mention quickly just to draw the committee's attention to. In terms of maritime enforcement powers, the Modern Slavery Bill included provisions to create new enforcement powers to tackle human trafficking and slavery offences at sea, and it's only those offences. And at that point, they were limited in extent to England and Wales only. Given the particular challenges posed by jurisdictional boundaries at sea, the Minister has been engaging with the Home Secretary and indeed the Scottish Cabinet Secretary for Justice to develop a comprehensive package of enforcement powers to cover the whole of the United Kingdom. Amendments to create these powers were agreed yesterday in Commons report stage. In developing our NI-specific proposals, we've been mindful to preserve PSNI primacy within Northern Ireland waters in all but hot pursuit situations, in that the police service must consent to operations into our waters, and we've also ensured that appropriate accountability arrangements are in place where operations take place in our waters. As we previously notified the committee, the Minister consulted the Chief Constable and the Policing Board on the proposals. They agreed that extension would be beneficial and would enhance our capacity to respond to these crimes. Taken in their entirety, the powers cover both devolved and non-devolved matters, and clearly what we are coming in due course to the committee and Assembly for is the powers in respect of devolved matters. Turning then to the Independent Anti-Slavery Commissioner, we've briefed you on that before and have made clear the Minister's proposal is to extend the Commissioner to Northern Ireland as an alternative to the Northern Ireland Rapporteur, which is currently provided for under Lord Morrow's bill. This proposal or approach received overwhelming support in our public consultation. The Minister believes that a Commissioner operating across the United Kingdom would provide a much better model than a local Rapporteur with the ability to oversee all relevant bodies operating here, whether devolved or not. Cost should not necessarily be the driving consideration, but in the current economic climate, obviously it's relevant, and a Commissioner operating across the whole UK would offer economies of scale and greater value for money. The paper sets out the detail, and in short, the key issues are there be consultation on appointment with us and on the strategic plan and annual report. There'd be new powers to allow each administration to request ad hoc reports from the Commissioner, and powers for the Minister to specify the public bodies within Northern Ireland that would have a duty to comply with the request for cooperation from the Commissioner. We've been engaging closely with Lord Morrow and his team on this particular proposal, and Lord Morrow naturally wants to see the content of the LCM before agreeing that he would drop his Northern Ireland Rapporteur from his bill. And as I've mentioned, we'd hopefully give him as well the content of that LCM very shortly. We hope that'll be enough to reassure him that his now clause 26 could be dropped from his bill at further consideration stage. The final area are the new provisions on enhancing transparency in supply chains. Given that the large size of companies which will be affected by this clause, there will actually be very few in Northern Ireland. The Minister believes, however, that a UK-wide response would be the most effective and appropriate way to legislate on this issue, and is keen to see the provision extend here to ensure consistency of approach. It would place a requirement on commercial organisations operating within the UK and supplying goods or services to prepare a slavery and human trafficking statement each financial year and to publish this on their website. The expectation is that the measure would capture approximately 1,000 of the largest organisations operating in the UK, but the detail of this would be established in regulations and there would be consultation with devolved administrations and, importantly, with business. I should mention at this point that business reps were consulted by the Home Office on the statement and there was broad support from them. Just to wrap up, we believe all three elements would further assist in strengthening the response to tackle modern slavery and human trafficking here, and as such will shortly be seeking the committee's support for the proposed LCM. Happy to take any questions now, obviously.
Okay, thank you very much, Simon. And obviously you've indicated you've been liaising with Lord Morrow on it, and did I pick you up right? He is content now that the Commissioner will do what we would want it to do.
He wanted to see the provisions in black and white from us, and because we had to wait for report stage, which was only yesterday, we weren't able to do that, but we certainly will in the next couple of days. And we're hopeful from the contact we've had to date that he'll be sympathetic to what we're doing.
Okay. Is there any members? I'm content with the LCM, so it's for any members who have any points they want to raise. It'll be, once it's laid, we'll have, it'll be referred to this committee, but obviously we'll turn it around in a short period of time. Mr. McCartney?
Sorry, Mr. Parr, is there a date set for when it's coming?
Next week.
Next week, okay, thank you.
Okay, so at that point it'll be referred to the committee. Members are aware of the issues from previous discussions, and obviously we have to produce a short report just on it, I think, as well. So if there's no other points of clarity needed from Simon and Julie, well, thank you very much.
Thank you very much.
Thank you. Okay, item 8. Pages 224 to 229 in your meeting folder. At our meeting on the 17th of December, the committee considered a report by the Examiner of Statutory Rules on delegated powers within the Justice Bill, in which he raised an issue in relation to the regulation-making powers in clauses 79(2), which is the general duty to progress criminal proceedings, and clause 80, which is around case management regulations, and agreed to refer it to the Department of Justice for a response. That has now been received, indicating that it is receptive to the issues raised, and at this point is minded to amend clauses 79 and 80 of the bill at consideration stage, giving effect to the examiner's suggestions. The Department will provide the wording of the proposed amendments to allow the committee to consider them before the completion of that committee stage, so that we can consider it. Item 9. Page 231 to 238 of your meeting folder, and also 86 to 110 of your table pack, relates to the Civil Legal Services Regulations. The Legal Aid and Coroner's Court Bill, when it receives royal assent and has commenced, the legislation governing civil legal aid will transfer from the 1981 order to the Access to Justice Northern Ireland Order 2003, and civil legal aid will become civil legal services. In order to commence civil legal services under the 2003 order, it is necessary to bring forward a range of subordinate legislation. As part of this, the Department is proposing to bring forward a statutory rule to make provision for the Legal Services Agency Northern Ireland, the Legal Aid Assessment Office, and solicitors to conduct financial eligibility assessments for legal aid applications for advice and assistance by way of representation and civil legal aid. The rule is largely a replication of the current means assessment, with two changes relating to the redefinition of assistance and representation, and decisions on applications for exceptional grant funding in individual cases, which will now move from the Department of Justice to the Director of Legal Aid Casework. Subject to the views of this committee, the Department intends to conduct a short targeted consultation on the draft regulations with key stakeholders. So, if members are content with the proposed statutory rule, or whether there's any other issues to consider, when we get the results of the short targeted consultation, obviously we can look at it again. unless there's more information members need now, we will take that approach. Item 10, update on the review of the statutory discount rate. A review of the discount rate, which is a percentage rate used by courts to calculate the amount by which an award of damages for future financial loss in personal injury actions is reduced, to take account of the fact that it is received in the form of an immediate payment which can be invested, has been ongoing in Northern Ireland, Scotland, England and Wales for a considerable period of time, and the committee received an oral briefing from departmental officials on this issue in May 2013. The department has now indicated to assist all three reviews a panel of experts will be appointed on a joint basis. The panel consists of 3 members who will each provide expert input on financial management of investments, actuarial issues and academic knowledge of relevant financial service market issues. The panel will report within 6 months and will advise on how the discount rate should be set and consider the responses to the consultations that have taken place. The Minister of Justice will make the decision on the appropriate discount rate for Northern Ireland based on all available evidence and following receipt of the expert panel's advice. The Department will, of course, continue to update the Committee. So it's for members to note the current position in respect of the review of this issue. Noted. Item 11. The 5-year victim and witness strategy included a commitment to gather information on the experiences of victims of serious crime, including those bereaved through murder, manslaughter and culpable road death. Excuse me. The Department has advised that research which provides an insight into these experiences has been completed, and 2 summary reports have been published on its website. The Department, in conjunction with the criminal justice agencies and voluntary sector providers, has considered the issues raised in the reports and developed a response paper and associated action plan, which has also been published. The findings generally mirror the findings of the committee inquiry. Views on the treatment by the criminal justice agencies were mixed. Many commented on the helpfulness of individuals they met, but there was a common perception that there was little recognition of their status as victims by the system, and many expressed a desire for more official recognition of the traumatic nature of their situation, which was often missing in the routine of criminal justice processes. There was also a view that there was a systemic imbalance that needed to be addressed in the treatment that the victim's family received in comparison to that of the accused person, and the need for improved information about the process in general and progress of their case, as well as opportunities to express their opinions and feelings, was emphasised. The Department, in its response to the findings, indicates some of the changes being made, such as the creation of the Victim and Witness Care Unit and the publication of a victim charter, will address some of the issues highlighted in the research, but acknowledges that more can still be done, and this will be taken forward through the action plan. So that research is there for members to note. I think it vindicates the decision the committee took right at the start of this mandate to actually do its own inquiry into it. It backs up the evidence that we found and listened to, the response from the Department to do with the Victim, Witness and Care Unit and the Victims Charter were both key recommendations that this committee made at the time. Correspondence, there are 17 items of correspondence, 2 items in your table pack, and I'll draw attention to a number of them. Item 1 in the meeting folder is correspondence from the Department regarding the timescale for the introduction of the Mental Capacity Bill. The Department has indicated that it is working with the Department of Health to complete an analysis of the responses from the public consultation on this draft bill, and both departments continue to work with the Legislative Council to finalise draft clauses for the bill. The departments aim to be in a position to seek executive approval in March 2015 to introduce the bill to the Assembly. This current timescale represents a further slippage of several months. The previous timescale for its introduction was anticipated for January of 2015, so that information is there for members to note. Item 3 is a response from the Department providing information on the impact of budget cuts on the Youth Justice Agency. Following the oral evidence session with the Minister on the 1st of October on the in-year financial position and outcome of the June monitoring round, the Department has indicated the Youth Justice Agency budget was reduced by 5.5% following the outcome of the June monitoring round, equating to just over £1 million. The budget cuts will result in a reduction in corporate and custodial services staff and non-staff costs, a reduction in funding available to purchase services from the external voluntary sector that will impact on support services and mentoring for young people, and a reduction in expenditure on vocational education in the Juvenile Justice Centre, and that information is there, members, to note. Item 5 is a copy of the Minister's response to the committee for the Office of the Minister of Justice's response to the committee for OFDFM in respect of their inquiry into building a united community. The response focuses on issues that need to be addressed in order for interface barriers to be removed and outlines the work undertaken by the Department of Justice in this area. So that information is there for noting. Item 16 in the meeting folder. This is correspondence from Mr Glenn, who is requesting a meeting regarding concerns in relation to the Police Federation of Northern Ireland and the Department of Justice handling of proposed police pension changes and a failure to actively involve police officers in the consultation process. And if members are content, we will seek to have an informal meeting that I and the Deputy Chair, and if there are other members who wish to attend, we'll make you aware of that when it's arranged.
Chair, could I just say that obviously I approve of that, and I think it would be welcome if other colleagues could attend that, but I do think that there's a very serious issue here, and one which I think should receive some sort of formal presentation by Mr Glenn and other of his colleagues before this committee at some stage. I'm not saying immediately, but my understanding is that regulations may be presented to the Assembly sometime in the first quarter of next year. So we would need to act reasonably quickly to determine the issues involved here. I think there are important issues involved, and I think that we should be very sensitive to the views of rank and file officers of the PSNI.
Okay, well, as a first step, we'll set up an informal meeting for the committee to facilitate them, and then we can take action thereafter. Okay. Item 1 in the table pack is a response from the Department in relation to the issues raised by the Disabled Police Officers Association regarding the handling of an investigation by the Charities Commission for Northern Ireland, the impact on the Association's work and the services provided to disabled police officers, the role of the Department of Justice in accessing the Association's premises and potential breaches of data security. The response indicates that a member of the Department Security Branch attended the DPOANI offices on the 13th of August this year in the presence of the Charity Commission and 2 trustees of the DPOANI, and that his role was to provide advice and guidance to the DPOANI following concerns raised by the Commission over the storage of information within the offices. The Department also advises that the documents removed by the Commission are held in a PSNI approved secure facility, and that all Charity Commission staff who have access to the documents hold appropriate security clearance. The Department has also indicated that DPOANI's audited accounts demonstrate that the suspension of funding of around £42,000 per annum from the police fund is unlikely to have a critical impact on the Association's ability to deliver a full programme for its members. So if members are content, we will forward this letter to those that had brought it to the committee's attention, and obviously if they want to raise matters to that, then they will be able to do so, and the committee can consider then if there's any further action required. I know at the time it was Mr McCartney indicated that we would facilitate them coming to the committee if that was desired, so we'll write to the association, and if they want to follow things up, then we can consider that in due course. Item 2 in the table pack is a letter from NIPSA to the Minister of Justice regarding the implication of the Department's funding cut to NIACRO and a request to meet with individual parties on the matter. The letter indicates funding cut by the Department of 90,000 will result in a loss of match funding from Europe, resulting in an overall 270,000 reduction in NIACRO's budget, with the result that NIPSA have been advised at the joint negotiating forum that the whole of the workforce will be placed on protective notice for redundancy from the 1st of January. This will have obviously an impact on staff and service provision. NIPSA has requested a meeting with the Minister of Justice to discuss this issue, and has also asked to meet with the parties on an individual basis, so it's there for members' information, and obviously NIPSA will make contact with the different parties in respect of it. Is there any comments on correspondence I haven't mentioned? If not, we'll action it as outlined in the meeting folder. Briefly on the Chairman's business, the information on members' attendance at committee meetings has been checked and verified, and then will be placed on the committee webpage on Friday the 7th of November. Any other business?
I want to say, earlier on this week, someone was met the probation board just to update what we're doing. I understand some of the progress we made and some of the new initiatives. I'm just wondering, would it be possible to have in at some stage as part of the future work programme, Chair?
We'll certainly see if we can facilitate that, yeah.
Okay.
They're an organisation that we've met with regularly. Indeed, we held an official committee meeting in the probation board's offices up in Antrim, so we've certainly had a good working relationship with them. So yeah, by all means, we'll try and factor something in future. Okay, date and time for the next meeting is next Wednesday, 2 p.m. In room 21. Thank you.